Hey, Matt, got your question about copyright. So, if you are applying this in your class, for those of you who don't know me, my name is Ruth Carter and I am a licensed attorney in Arizona. I do work in copyright, trademarks, business contracts, and social media law. So, you sent me a question asking about copyright in photographs, and you proposed the hypothetical. I'm going to change the names for my own ease. If John asks Sue to take a picture of him and he gives her his camera to take the photograph, who owns the copyright? Well, So to have a copyright, you need an original work of authorship fixed in a tangible medium. So in my mind, if Sue was the one clicking the shutter, she was the one who actually fixed the work in the tangible medium, but perhaps John was the one who came up with the original idea. However, there is no copyright in ideas. It's only in expression. So unless it's a situation where John set everything up and all Sue had to do was click the shutter, I would say maybe in that situation, John would have copyright. Otherwise, I'm actually leaning towards Sue because even though it was his idea to have a photograph taken, and it was his camera, it would still, she was still the one who made it happen. I kind of think of this similar to a situation where, let's say you hired a graphic designer to design your website for you and you asked them to use your software in your computer. Well, they were still the ones who put fingers to keyboard. So even though you're the one who told the designer exactly how you wanted it to look, they were the one that brought it into fruition or into existence. So I lean toward the person who actually did the creating is the copyright. Now, there are situations where people do intend to be joint authors, so maybe this is a situation where was their intention, but it sounds more like John directed Sue to take the photograph. So if John wanted to be the copyright holder, he may have to get some type of copyright assignment for her, or they should have had some type of work made for hire contract in advance. So these are potentially complicated situations depending on the people involved and how much they want to fight over it. Or if it is like, hey, buddy, take my photo and use my camera. Probably the person who clicked the photo doesn't care about having copyright in a photo of you, standing on a mountain or wherever it is you're taking the photo. So you also have to look at the motivation of the people involved. But in general, it's the person who does the creating that is usually the copyright holder, unless it's a situation where it's a work made for hire that's in writing, or it's an employee creating work for their employer. So I hope this answers your question. If you want to chat more, shoot me an email, rcarter@venjuris.com or ruth@carterlawaz.com. All right, talk to you later.